because people say, oh, well, they're younger than me. They won't die. They won't die before me, but things happen. Had they done that, the children of their cousins, who are very much alive and would be very happy to have this portion of the estate, would have benefited, but they won't because of the way that the will was drafted.
You're listening to the Women's Wealth Canada podcast with Glory Gray. Be sure to download and subscribe using your favorite podcast app and like us on Facebook.
Are you going through a life transition and need to find a wealth advisor to manage your investments? You don't have to feel intimidated wondering how to find the right one. Grab my free guide, 12 Smart Questions to Ask When Interviewing a Wealth Advisor. This guide gives you all the questions and why you should ask them. Just go to glorygray.com, pop in your email address, and we'll send it right to your inbox. Hi everyone, I'm Glory Gray and welcome to the Women's Wealth Canada podcast. When we produce these podcasts and blogs for you, we try to keep them short and sweet so you can gain valuable information, have time to digest it, and listen while you're multitasking. That's right, I see you. I know you're doing something else right now. No judgment. I get caught up on podcasts that I listen to while I'm cooking and doing the dishes. The topics we're covering today are so important and there's so much information that we've split it into 2 episodes for you. So be sure to come back next month when we share part 2 with you. And what's this big topic? One of the most important topics I work with my clients on, estate planning for everyone. Joining me today is lawyer Jennifer Sandford. Jen was a lawyer in Montreal and Toronto before joining Horn Cooper LLP in Victoria, BC. She specializes in wills, estates, trusts, tax planning, and taxpayer representation. She's a regular contributor to the national newsletter of the Society of Estate and Trust Practitioners Canada. And she also co-authored a chapter on the subject of estates and adult guardianship for the Continuing Legal Education Society of British Columbia. Come listen in as Jennifer and I chat about simple estate planning for everyone. So Jen, why does someone need a will?
I'd like to maybe step back and talk about what is a will. And a will is a document that expresses your intentions about what you want to do with your assets after you die. There are certain formalities required, but essentially you can give those instructions and change those instructions as many times as you like, as long as you have capacity until your death. So I guess there's 2 parts to that question. Why a will? There are laws that help govern the division and administration of your assets, even if you don't have a will, which I think is something we're going to talk about later. But if you don't want to give your estate to your family, or you wanted to give some gifts to friends or to charities, or if you had stepchildren or foster children that you wanted to give part of your assets to, they would not be provided for under the intestate laws. Intestate means dying without a will. And so if you intended to spread your estate and give a little bit to lots of people who've meant something to you as a thank you or just in recognition of the role and joy they've brought to your life, then you should have a will. And that's one way that you can ensure that they will receive something as you intended.
I had someone who said that a will makes things easier for the people you've left.
If you have a good will, if you have a well-drafted will, it does. Unfortunately, a lot of people have very simple wills, wills that are a page or 2, and that can lead to a lot of confusion. If there's any vague language, it can create more problems And I guess maybe I should just pause and say, I've said that, everybody has the freedom to make a will as long as they have capacity. And capacity means the ability to give instructions, legal ability. So if you've had a head injury and you're not able to make rational decisions, you might not have legal capacity. But in general, as long as you have capacity, you can make a will and decide what you want to do with your assets, and you can change your decision. You can change your mind. However, the laws in BC and in a number of jurisdictions across Canada will operate to protect some rights to your assets. So you might decide that you don't want to give any money to your children, or you might say that at the end of your life, you choose to cut your wife out or your spouse out of your will. And if you do that, they have an ability to challenge your will in court and argue that they were not adequately provided for. And if the court determines that they were not adequately provided for, the court will change the terms of your will to provide a little bit more to either your spouse or your children. And so that there are different things that you need to do to be able to ensure that you're meeting your obligations. And there are different planning techniques to make sure that your instructions are respected and limit the ability of your children and your spouse to challenge your will.
Okay, so we don't have to feel like there's nothing we can do. There are steps we can put in place ahead of time to allow that our wishes are met.
That's right. There's a number of planning techniques depending on the nature of your asset and the nature of the issue. There are things that you can put in place that ensure that your wishes and instructions are met.
So let's back up then. What happens if I don't have a will at all and I'm in intestate, as you say?
Yeah. So if you die without a will, there's very clear instruction. It's not that your estate will go to the government, although that could happen if you have no family. But generally what happens, the laws provide for a division of your asset between a spouse, if you have one, and your children, if you have one or more. There's a preferential amount. There's an additional amount given to your spouse than to your children. And then it's, in general, an equal division after that preferential piece to your wife and your spouse and your children. And if you don't have a spouse, if you don't have children, then they go beyond that. They look to parents up above, siblings, and they can go as far as cousins. For example, if you don't have any family, don't have any close family on your death, and you don't have a will, the Act does not allow your estate to go beyond cousins. So second cousins, they're not going to get anything. So you do have family, but the law does not provide for them. And so at that point, your estate would go to the government. It becomes the government's property. There's only a certain number of degrees of distance from you that they'll allow you that they will distribute it out to family.
And then it just simply goes up for estate sales?
Yeah, it goes to the government and it becomes part of the government's property. I believe they hold it for 10 years just in case there is somebody who comes forward. And I had a situation like that, which is maybe helpful. A client, not a client of ours, that we didn't prepare the will, but they did have a will. And they provided for two cousins to be the executor and to receive half of the residue, what was left over in the estate. Both of those cousins died before the will maker. So the half that would have gone to those cousins is now going to go to the government because there were no siblings, no parents, no children, no spouse, no grandparents. And although there are second cousins, children of the cousins, it's one step beyond what's permitted. So that particular gift fails and it's going to go to the government.
I can see that happening more often as we are living well into, and there's a lot of centenarians on this island.
That's it. And so that's one of the things that you hope a good lawyer or notary, whomever you choose to see for a will, is going to ask those questions. Well, that's very nice. You want to provide for your cousin. And what happens if your cousin dies before you? Do you want it to go to their children? Do you want it to go to a charity? Those are the questions you need to prompt, because people say, oh, well, they're younger than me. They won't die. They won't die before me, but things happen. Had they done that, the children of their cousins, who are very much alive and would be very happy to have this, a portion of the estate, would have benefited. But they won't, because of the way that the will was drafted.
Now, there are online will kits and paper will kits you can buy, but are there inherent problems in not using a lawyer or a notary to prepare a will in light of these clauses that you're talking about?
I think, lawyers are expensive. And I think that if you intend to provide for somebody other than your spouse and your children, but can't afford a lawyer, then there's nothing wrong with the will kit. There's nothing wrong with the online kit. They're going to prompt you to complete it and prepare it in a form that's acceptable by our probate courts. So I wouldn't say there's anything wrong with them. The problem is, if you have any significant assets, if you have a blended family, if there's any potential conflict in your family, which, I mean, admittedly, how many families don't have conflict, that could be an issue. And although you're saving a few $100s in the preparation of the will, that's just a couple of hours of lawyer's time in the context of any kind of litigation against your estate. And so the fear that I have is that the estate is basically depleted by litigation. And the way that works is often the executor is the person who's defending the claim on behalf of the estate that they're administering. And their costs, their legal fees, are all going to be covered by the estate. And so it can be ground down pretty quickly. So there's nothing wrong with a will kit, absolutely not. But I will say, unlike things like, the online tax preparing software, I use that. It's very helpful. I wouldn't say that estate planning is a 1+1 calculation. You're dealing with family, you're dealing with objects of sentimental value, as well as of financial value, your life savings. In general, I think most people want there to be no conflict after they die in respect of their estate. They don't want there to be infighting amongst their family. As I said, a will kit is useful, and it gets the job done, and it'll have the proper formalities to be valid. But the value of having a conversation with a lawyer is that a good lawyer is going to tease out the questions and the real issues, looking at your assets, looking at your family dynamics. You want to provide for your spouse, but you also want to provide for your children. And how do you do that? I don't know whether a will kit is going to be able to prompt you with that information. And I think that there are solutions, empathetic, careful solutions that a good lawyer is going to be able to suggest for difficult situations, difficult family situations.
Those family dynamics again. How often should one review their will and update it?
Generally, I would say whenever there is a change in your circumstances. If you prepared a will while your children were young, when they've reached majority or when they're on the cusp of reaching majority, that might be a time to revisit. If you get married, if you get divorced, if there's a change in your relationship, if there's a change in your health or your family's health, those would all be things that you might want to consider. If you've received an inheritance yourself, if there's, and what I mean by that is you may wish to give everything to your spouse on your death, but maybe the inheritance you receive from your parents or from a family member you would like to save that for your children. So the life that you've built together with your spouse, you share with your spouse. But the gift, the windfall that you received from a family member, maybe that's a legacy gift that goes down on to the next generation.
Now, I have some clients who move here from other provinces, and they ask if their will is going to still be good. If they came here from Alberta and now they're living in British Columbia, is their will still good, or do they need an amendment?
The wills that are prepared in other jurisdictions are generally valid. What might need to happen, though, is depending on your asset mix, you might need to get probate in the jurisdiction where the will was situated, where you have some assets, and then what's called resealing it in the jurisdiction where you live. And it can delay the administration of your estate. But there's also times that I had a client who moved from another province, and when he came to me, he didn't have capacity anymore to prepare a will and give instructions for a will. So his will from the other jurisdiction will have to do. And it just is what it is.
And it used to be that when we were remarried, I believe, or it might be divorced, you can correct me on that, our previous will was no longer valid. Is there something to that?
It depends on the jurisdiction. In BC, it's not the will that's invalid, but let's say you appoint your spouse as your executor and as your primary beneficiary. If you're divorced or not even divorced, let's say separated, then the gift and the appointment as executor is null and void. So it's as if they've predeceased you and the will is administered to the people who were receiving the gift after the death of your spouse. It doesn't mean that spouse doesn't have any rights to your estate. They just don't have any rights under succession law. Their rights would be under family law. So, for example, we had a client who had a will, passed away. He was in the process of separating from his common law spouse. They hadn't sorted out the division of assets and so on. So her rights to his estate were under family law. And so they had to sort out the family law issue. But any gifts that he had given to her in his will were voided. And I will say there's a caveat to that. If you are divorced or separated, let's say you are separated in July, and in September you create a new will, and in that you provide a gift for your spouse, your ex-spouse, the courts would probably interpret that as being an intention to make a gift, even though you were separated. And again, a good lawyer is going to make that very clear in the will, even though, make clear that despite the fact that we've been separated, I still want to recognize my spouse for the contributions they've made to my life. And this is the gift I'm intending to give to them.
So making clear it's just not an oversight, it was an intention.
Yeah, that is very key in all the way through. I'll give an example. So our wills, estates and succession law in BC provides very specifically that you're designated beneficiary. So if you've got an asset where you designate a beneficiary, for example, an RSP or a RIF, you say, on my death, it's to my children. Well, our law says that passes outside the will. It's an automatic gift. It doesn't go through your will. But the courts have interpreted that differently. The courts have said, well, we think that, in fact, that transfer was just to that person in trust for your estate. And really, they're just holding it and they should put it back into your estate to be administered according to your will, which is not your intention when you create a designated beneficiary. So now our wills make it really clear, any designated beneficiaries that I have named in my lifetime from now until my death, it was my intention that that be a gift and that pass outside my will. And we make that very clear in the will. And same with any joint assets. If you hold a house in joint tenancy, if you hold a joint account, we make that very clear because the courts also have a tendency and have on a regular basis determined that if you transfer, if you hold an account, a joint account with, for example, an adult child, the courts have interpreted that as being something where they say, well, the adult child was actually holding it for their parent as a convenience, and the intention was that that be administered under the estate. So it's not theirs personally on the death of the parent.
And, that gives me some kind of comfort. The fact that you say that is that we can write these clauses that say in the future, because, we're going in and out of accounts all the time, right? We have an RSP here and a TFSA here, and we may have designated the beneficiary to go to our children. And you're saying that we can prepare the will properly to say, when I do this in the future, this is what I meant.
That's the language you use. Any that I have now or any that I designate in the future, because obviously our estate is changing all the time. We're using our money, we're contributing money, we're investing, we're growing our money, hopefully. And so the idea is it's constantly in flux. And we're just saying, whatever I have on my death, if I have designated beneficiaries, it's my intention that they go as a gift automatically, not through the will.
Now, so what is the role of the executor?
So the executor's job is to administer the estate in the most broad sense. They need to inventory all of the assets, those that are passing by will, as well as the assets that have passed outside of the will. So the joint assets, the assets on which there was a designated beneficiary, they need to inventory all of them. They need to make sure that all of the debts are paid from the estate. They get probate if necessary. Probate is essentially proving the will, proving that the individual who's been named as executor is properly authorized, that what they're dealing with is the last will of the individual who's passed away. And then it's their job to administer the estate according to the will where possible. There may be challenges to the will that lead to litigation or negotiations about how the estate should be distributed. And there is a great personal liability that attaches to acting as an executor. It's a huge responsibility. You're responsible for making sure the debts get paid. And we recommend that people advertise for creditors. There's a way to do that. If you don't advertise for creditors, which provides a time limit for those creditors to come forward. If you don't advertise for creditors and you've distributed the estate, you will personally, as executor, be responsible for paying them back. In the same manner, if you make distributions to beneficiaries because they're pressuring you and they're saying, I just want my money, and you think that maybe you've paid all the taxes, but you're not quite sure, well, if you do make distributions and it turns out that there is tax owing on the estate, again, the executor is personally liable for those taxes, as well as penalties, as well as interest. The wills, you hope, provide for some indemnification for the executor, because why would they ever take on this role if they're going to have to pay out of pocket and potentially lose their house because there's claims made against the estate that they can't satisfy. But it is a very serious job, and they need to make sure that they get good advice, good guidance from accountants and lawyers and investment professionals to make sure that they're doing the right thing in administering the estate. So you need to choose your executor very carefully.
Does your firm sometimes take on those executor roles?
Yes. Yeah. So law firms, estate law firms such as mine, we do act as executors. There's also financial institutions also offer those services. Because this is a really thankless task, really. I often, where there's family tension or where there's multiple, for example, if there's multiple adult children that don't get along or don't have the skill set for being executors, my recommendation, the gift I say that they can give to their family is to hire or to name a professional trustee to act as executor. Yes, it's probably more expensive, but chances are, because this is what professional trustees do for a living, it'll be done efficiently and cost effectively. And for the family or for the beneficiaries, if there is tension, they can point at the professional executor and be mad at them instead of mad at within the family. because there's always somebody who's looking over your shoulder saying, I could have done that better. I could have done that more efficiently, more cost effectively. And if you've got a professional, then, they can be the bad guy, and it's okay. They can take it. They're being paid for that.
I've had some clients ask me if their executor can be someone who lives in another country.
So that's tricky. From a Canadian tax perspective, we would not recommend that. Essentially, your estate for income tax purposes is a trust. And the person administering your trust is considered the trustee. And the residence of the trustee determines the residence of the trust. So if all the decisions are being made by the trustee, let's say in England, then this is considered to be a non-resident trust. And there's additional complications. You will need to, for example, if you sell a house in the estate, the trustee will now need to get a clearance certificate called a Section 116 certificate to sell the house and make sure that the proper amount of taxes have been withheld and remitted to the government. It just adds a lot of complication. So where there are clients whose entire family lives outside of Canada, our recommendation is to name a professional trustee. It just makes it simpler.
And the thing for our listeners to remember is that a professional trustee is an entity that's going to continue beyond the lives of people that you might have stated as your executive.
That's a really good point. You have the comfort, if you're choosing a firm or a financial institution, you have the comfort that if that particular individual with whom you had a relationship predeceases you or leaves the company, there's someone else to pick up the file and keep moving forward.
That's all for today. Join us next time for the conclusion of my discussion with Jennifer Sandford on simple estate planning for everyone. And we'll be talking about the important steps for you to take that protect you in your own lifetime. If this podcast helped you, please subscribe, leave us a positive review on Apple Podcasts, and tell others about it so that we can help them too. Until next time, this is Glory Gray, your personal trainer for financial fitness, telling you to take charge of your finances, plan for the future, but most of all, enjoy today, and bye for now.
This podcast is for informational purposes only and should not be construed as investment, tax, or legal advice. It is not an offer to sell or buy, or an endorsement, recommendation, or sponsorship of any entity or security cited. Mutual funds offered through Portfolio Strategies Corporation. Other products and services provided through Glory Gray Wealth Solutions.